Ninth Circuit was the only circuit to uphold what I refer to as a default rule law. And, well, that created a conflict between the circuits. And under Rule 10 of the U.S. Supreme Court rules, the number one reason the Supreme Court will review something is if federal law means something different in two different parts of the country. You can't have First Amendment mean one thing in Maine and another thing in California. The whole job of the Supreme Court is to create uniformity in federal law across the nation. So I identified a circuit conflict between the Second Circuit and the Third Circuit with the Ninth Circuit on this question presented. And
so Alan, that's called a jurisdictional split, right?
Yes, I typically refer to it as a circuit conflict or a circuit split. But right, but I've never heard it referred to as a jurisdictional split, but it probably could be used as well too.
Okay.
But and identified the circuit conflict and asked the Supreme Court to review. And well, the Supreme Court did review. So here we are. We have filed our opening brief with the U.S. Supreme Court, and the state of Hawaii has filed its response brief. And right now, I'm preparing my reply brief, and that will be the last paperwork submitted to the Supreme Court. That on January 20th, I will be going before the U.S. Supreme Court and arguing this matter on behalf of my clients. And all three of my clients, they're residents of the county of Maui, the island of Maui, which is also a county that encompasses a couple other islands. And, they all have CCWs. They were carried just fine for about a year after the Bruen opinion. Then the state of Hawaii put in this onerous restrictions. And, thankfully, we still have a restraining order in place, so they can't carry to this day. But, the whole point of this case is to keep them carrying so they can exercise their Second Amendments. And this is just truth. Ever since we put in, they started issuing permits, there have been no issues. The state of Hawaii is afraid of, a fantasy that they've concocted in their own mind that somehow these very dangerous people are going to be walking around just brandishing firearms. The reality is, this is part of the briefing. My clients, along with all CCWs, are the safest demographic. They get a lot of training as a requirement, and most of these guys get a lot of training because they want to. None of them have ever been convicted of a serious crime. They don't abuse drugs or alcohol. They're mentally fit. These are all requirements they have to prove in order to get these CCW permits. So, and they have a lower arrest rate on average than police officers. So there's just...
Well, hold on a minute, Alan. I mean, how come I don't hear about any of this on CNN or PMSNBC?
Well, this might come as a shock to you, but it might be that CNN doesn't want these statistics to get out there.
And by the way, Rhinelab says, very good job at getting heard by the Supremes. And Jody says, Michael, always good to see you. Always good to see you too, Jody. Go ahead, Alan.
So, that's where we're at, The state of Hawaii has filed their answering brief, and they made some pretty interesting arguments in there, as we discussed earlier, Mike. Probably the 2 points that honestly are just, to me, a little shocking is one, they've endorsed the use. They have to come up with the historical analogs. And, they only came up with 2 that the Ninth Circuit believed in. And one of our arguments, 2 isn't enough, but even if they are, these 2 aren't very good either. One of them is a 1865 Black Code. For your viewers who don't know what Black Code is, that refers to a series of laws that were passed right after the end of the Civil War that were expressly designed to disenfranchise African Americans that had just been freed from slavery, because the southern states didn't want them to be able to exercise their constitutional rights, especially the right to firearm carry. So the state of Hawaii has actually defended its law. They concede that is a Black Code. In fact, Mike, at some point, it'd be nice if you could pull up from their brief and put up for everyone to see where they defend. Hey, I can look it for you, and you can just put up for the whole world to see that the state of Hawaii is saying, we acknowledge we're using a Black Code, and this is absolutely okay.
Well, I'm going to search for it now while you're talking. I see a lot of amicus briefs on here. Here's what I'll do. I'm going to share the screen right now. Hopefully you can see.
Yeah. I want you to scroll down Keep scrolling down. Keep going down.
Man, you got a lot of amicus
Yeah,
briefs.
yeah.
Holy crap.
A lot of people care about this case. So go to brief of respondent. Sorry, go to December 17th.
By the way, can you tell the audience what an amicus brief is?
An amicus brief is a friend of the court. That is a brief written by a third party that has an interest in the case and wants the Supreme Court to listen to them in a certain way. So here we have an amicus brief from the United States. The Trump administration has come in support of me, and they will also be arguing. We also have an amicus brief on behalf of what's effectively 25 states in support of me. It's 24 states plus the Arizona legislature. I don't know how their politics works there, so I'm just going to call them 25 states.
Yeah.
So that's over half the country in support of me. And right. And on the other side, they only got, I say it was like 7 or 8 states to go on to defend them, And bottom line, so that's the one law that I found pretty shocking they'd be using.
So they're using I wonder how Ketanji Brown's going to feel about that, because we know we know that she's not exactly a supporter of the Second Amendment. So this will be.
We actually don't know that.
Okay.
We can infer that, but we don't have a lot of track record on what Justice Jackson thinks about the Second Amendment, so she could surprise us, right? I mean, I certainly would, I'll find it interesting to see how the black coat argument goes over with Justice Jackson, frankly, all the justices.
Yeah.
But it's so I am going to
tell me where to scroll down to, what page.
Yeah, so it is on page 37 of the answering brief.
Just give me a second. Man, this is a heck of a brief, buddy.
Woo. Yep. It's both these briefs took a lot of work, both mine and the states. And, they have hired the Solicitor General under Barack Obama.
I was going to ask you. I kind of thought it was going to be Obama, of course.
Yep. I mean,
arguing the black codes. That's unbelievable.
Go number 4.
All right. So here we are. So I can go ahead and read it if you want.
Yeah, if you just go to number 4, yeah.
Petitioners further argue that the 1865 Louisiana law should be disregarded because it was adopted. By the way, you're the petitioner, just so the audience knows. Alan's the petitioner. Well, his client is, but Alan's the attorney. This is Alan's case. I'm very proud of Alan. By the way, really quickly, I just want to tell you a little bit about the background of Alan. Alan is an inactive U.S. Marine. He's got a black belt in Brazilian Jiu-Jitsu. He's a good buddy of mine, and I've known him for years, and I'm just absolutely blown away. He's been all over the news. He's really just nailed it. But anyways,
I'm actually of counsel with Ehline Law on occasion. I help Mike out on it once in a while with some work. This takes up most of my time, though, so unfortunately, we can't, not as much as I would like, because it's always a pleasure to work with Michael when I have the opportunity.
I appreciate the kind remark. The other issue is we get a lot of people on YouTube who have basically, for lack of a better word, their own personal crusade with their own Second Amendment rights cases. But what Alan is doing, and what I'm trying to do with Alan, is to get laws passed so we don't have to help you with your personal crusade. So we focus on what we think really matters, which is getting the gun laws changed to what our founding fathers expected for the country. So give me a bunch of ones if you agree that's a better approach.